Good afternoon, everyone. This is the case of the people of the state of Colorado versus James Egan Holmes, case number 12CR 1522. The record should reflect that Mr. Holmes is present with his attorneys, and the prosecutors are present as well. Dr. Reed is present as well. Let me address the bench conference that we had at the end of the morning session. And for the record, the jury has exited the courtroom. In fact, the jury did so before the lunch break, and so that we are outside the presence of the jury. Is anybody asking that Dr. Reed step out, or is everybody okay with us having this discussion in his presence?
I think he should not be present, Your Honor.
All right, let's have him step out for just a moment. Doctor, if you don't mind. All right, for the record, Dr. Reed has now stepped out of the courtroom. The question that drew an objection was as follows. Was it also part of that standard that you're going to apply to this, that the defendant suffered from a mental disease or defect that prevented him from forming the intent to commit murder after deliberation? Dr. Reed then answered in a non-responsive manner that his opinion is that whatever the defendant suffered from, it did not prevent him from forming the intent and knowing what he was doing and of the consequences of what he was doing. During the lunch break, I went back and reviewed People versus Herrera, which is published at 87 Pacific 3rd, 240, Colorado Court of Appeals case from 2003, which was discussed in my order D-246. As relevant here, Herrera and other cases such as People versus Herdman, Herdman, 310 Pacific 3rd, 170, Colorado Court of Appeals 2012, and People versus Bondurant, Bondurant, 296 Pacific 3rd, 200, Colorado Court of Appeals 2012, make clear that sections 16-8-107, subsection 1A, and subsection 1.5a limit the admission of information obtained during a court order examination to the issues that are raised by the plea of not guilty by reason of insanity. Therefore, a court-appointed sanity examiner cannot testify as to the ultimate issue of the defendant's culpability or guilt, or as to whether the defendant actually acted with the culpable mental state that is an element of a crime charged. By the way, that's consistent with the limiting instruction that we all have agreed I have to give the jury in this case, and that is that the jury may consider certain evidence only for the limited purpose of assessing the issues raised by the insanity defense. And more specifically, that instruction applies to information obtained for the first time during a court order examination. So what are the issues raised by the insanity defense? Well, I think to answer that question, you have to look at the definition of insanity. And the applicable test of insanity in Colorado is a two-part test. Number one, a person who is so diseased or defective in mind at the time of the commission of the act as to be incapable of distinguishing right from wrong with respect to that act is not accountable. Or, number two, a person who suffers from a condition of mind caused by mental disease or defect that prevented the person from forming a culpable mental state that is an essential element of a crime charged. And notice that the first prong of that test uses the term incapable, while the second prong uses the term prevented. I read those to convey generally the same meaning, and that is that I understand the use of the word prevented in that second prong of the test to refer to as not being able or capable of forming a culpable mental state, as opposed to not actually forming a culpable mental state. The language that was used by Mr. Brockler in his question and by Dr. Reed in his answer is consistent with the second prong of the test that I just read, the insanity test that applies in Colorado. In fact, Mr. Brockler used prevented instead of incapable when asking about the first part of the test. And I know that he wasn't asking Dr. Reed to give an opinion. He was asking Dr. Reed about the standard that applies. And in asking about the first prong of the test, he used the word prevented as well instead of incapable. And there was no objection to that question. And again, I think that term is similar, at least as used in the statute, to incapable. I think incapable and prevented are used similarly in the statute. So after looking at Herrera, looking at the statute that I cited a moment ago over the lunch break, I have concluded that there has been no violation of Order D-246 and that there has been no improper testimony. Therefore, the motion to strike, the answer is denied, and the motion for a mistrial is likewise denied. Now, having said all that, let me address the defense's concern. I do think that someone could misunderstand the use of the term prevented to imply that the defendant actually formed a culpable mental state required by a crime charged. And so I think counsel and the witnesses should avoid the term. Instead, I think the terms capacity or capable or incapable should be used because they make it clear that what the witness is talking about is whether someone has the capacity to form a mental state as opposed to whether someone actually formed a mental state, a particular mental state. And then the last thing is that I think it's appropriate to have Mr. Brockler clarify with Dr. Reed what he meant. And I think it should be clear to the jury that Dr. Reed is not opining about whether the defendant actually distinguished right from wrong or whether the defendant actually formed a culpable mental state that is an element of a crime charged. It should be made clear that what he's opining about is whether the defendant was so diseased or defective in mind as to be incapable of distinguishing right from wrong, and he is opining about whether the defendant suffered from a mental disease or defect that rendered him incapable of forming a culpable mental state that is an element of a crime charged. I think that makes it very clear, and I think that avoids any misinterpretation, and I think that's consistent as well with the statutes that I have cited, and it's consistent with Herrera and the other case law. So